ओके। सो आज हम यहाँ तक पहले हमने कवर कर लिया था। अब एथिक्स लॉ कम्युनिकेशन में हम देखेंगे एथिकल थ्योरीज एंड फ्रेमवर्क। So key ethical theories are summarized in box 1.1. Key ethical theory: deontology. Deontology, a universally applicable rule or duty based approach to morality. Example: deontologist would argue that one should always tell truth irrespective of the consequences. Then consequentialism, an approach that argues that morality is located in consequences. Such an approach will focus on likely risk and benefit. Virtue ethics offers an approach in which particular traits of behavior are identified as desirable. Right theory assess morality with reference to the justified claim of others. Rights are either natural or arise from the being human, or legal and therefore enforceable in court. Positive right impose a duty on another to act, while negative right prohibit interference by other. Narrative ethics. Narrative ethics, an approach that argues morality is embedded in the stories shared between a patient and a clinician and allows for multiple perspectives. Many doctors find that ethical framework and tool which focus on the application of ethical theory to clinical problems are useful. Perhaps the best known is the four principle approach in which the principle are autonomy. Number one, to allow self-rule, that is, let patient make their own choices and to decide what happened to them. Beneficence, to do good, that is, act in a patient's best interest. Non-maleficence, avoid harm. Justice, treat people equitable and fairly. For some, a consistent process that is incorporates the best of each theoretical approach is helpful. So, whatever the ethical questions, one should summarize the problem and state the moral dilemma. Identify the assumption being made or to be made. Analyze with reference to ethical principle, consequences, professional guidance, and the law. Acknowledge other approaches and state the preferred approach with explanation. People respond differently to ethical theories and approach. Do not be afraid to experiment with the ways of thinking about ethics. It is worthwhile understanding other ethical approaches even in broad terms, as it helps in understanding how others might approach the same ethical problem, especially given the increasingly global context in which healthcare is delivered. Professional guidance and a code of practice, as well as ethical theories and framework. These there are codes of practice and professional guidance. For example, In the UK, the standards set out by the General Medical Council, that is GMC, are the basis on which doctors are regulated within the UK. If a doctor falls below the expectation of the GMC, disciplinary procedure may follow, irrespective of the harm caused or whether legal action ensues. In other countries, similar professional bodies exist to license doctor and regulate healthcare. All clinicians should be aware of the regulatory framework and professional standard in the country within which they are practicing. Increasingly, ethical practice and professionalism are considered significant from the earliest days of medical study and training. In the UK, attention has turned to the standard expected of a medical student. For example, in the UK, all medical schools are required to have fitness to practice procedure. Students should be aware of their professional obligation from the earliest days of their admission to a medical degree. All medical schools are effectively vouching for a student suitability for the provisional registration at graduation. Medical students commonly work with patients from the earliest days of their training and are privileged in the access they have to be vulnerable people, confidential information, sensitive situation. As such, medical school have particular responsibility to ensure that students behave professionally and are fit to study and eventually to practice medicine. The Hippocrates Oath, although well known, is outdated and something of an ethical curiosity, with the result that it is rarely, if ever, sworn. The symbolic value of taking an oath remains, however, and many medical schools expect students to make a formal commitment to maintain ethical standard. The laws, as it pertains to medicine, the law establishes boundaries for what is deemed to be acceptable professional practice. The law that applies to medicine is both national and international. Example, European Convention on Human Rights, Box 1.2, within the UK, along with other jurisdictions, both statute, sta- statutes and common law apply to the practice of medicine. Box 1.3. The majority of cases involving healthcare arises in the civil system. Occasionally, a medical case is subjected to criminal law. Example, when a patient dies in circumstances that could constitute manslaughter. Manslaughter. Box 1.2, European Convention on Human Rights. Substantive right which apply to evaluating good medical practice. Right to life, Article 2. Prohibition of torture, inhuman or degrading treatment or punishment, Article number 3. Prohibition of slavery and forced labor, Article 4. Right to liberty and security, Article 5. Right to a fair trials, Article 7. No punishment without law, Article 7. Right to respect for private and family life, Article 8. Freedom of thought, conscience and religion, Article 9. Freedom of expression, Article 10. Right to marry, Article 12. Prohibition of discrimination, Article number 14. Respect for autonomy, capacity and consent. Capacity. Capacity is the heart of ethical decision making because it is the gateway to self determination. Box 1.4. People are able to make choice only if they have capacity. The assessment of capacity is a significant undertaking. A patient's freedom to choose depend on it. If a person lacks capacity, it is meaningless to seek consent. In the UK, the Mental Capacity Act 2005 sets out the criteria for assessing whether a person has capacity to make a decision. See chapter number 23, page number 1191. Assessment of a capacity is not a one of judgment. Capacity can fluctuate and assessment of a capacity should be regularly reviewed. Capacity should be understood as task oriented. People may have capacity to make some choices but not others, and capacity is not automatically precluded by specific diagnosis or impairment. The way in which a doctor communicates can enhance or diminish a patient's capacity, as can pain, fatigue, and environment. Now, box 1.3, statutes and common laws. Statutes. Primary legislation made by the state, example Act of Parliament in the UK such as Mental Capacity Act 2005. Secondary or delegated legislation, supplementary laws made by an authority given the power to do so by the primary legislation. Implementation, that is statutory guidance, example the Mental Health Act Code of Practice. Common laws, judicial decision made in case. These establish precedent that are then applied to future cases. Whether a decision constitute a precedent depends on which court made the decision. Higher level court have authority over lower level courts. Now box 1.4, principle of self determination. Every adult has the right to make his or her own decision and to be assumed to have capacity unless proved otherwise. Everyone should be encouraged and enabled to make his or her own decision or to appreciate as fully as possible in decision making. Individuals have the right to make eccentric or unwise decision. Proxy decision should consider best interest, prioritizing what the patient would have wanted, and should be least restrictive of a basic right and a freedom. Principle underlying Mental Capacity Act 2005, England and Wales, which applies to patients over the age of 16 years. Consent. Consent is integral to ethical and lawful practice. To act without or in opposition to a patient's expressed valid consent is in many jurisdictions to commit an assault or battery. Obtaining informed consent fosters choice and gives meaning to autonomy. Valid consent is given by a patient who has capacity to make a choice about his or her care. Voluntary, that is free from undue pressure, coercion, or persuasion. Sufficiently informed. Continuing, that is patient should know that they can change their mind at any time. The basis of a informed consent. Those seeking consent for a particular procedure must be competent in the knowledge of how the procedure is performed and its problems. Whilst it it is common and good practice for written information to be provided to the patient. The existence of a written material and a consent from does not remove the responsibility to talk to the patient. The information given to a patient should be that which a reasonable person would require whilst being alert to the particular priorities and concern of individuals. Information shared should cover risk and benefit, explain possible consequences of a treatment and non-treatment, explain option, disclose uncertainty. This should be as much part of the decision as sharing what is well understood. Patients should be encouraged to ask questions and express their concern and preference since it is the health and life of a patient that are potentially at risk. The moral focus of such disclosure should be on what is acceptable to patient rather than to the professional. Consent in education setting. Much medical education and training takes place in the clinical environment. Future doctors have to learn new skill and apply their knowledge to the real patient. However, patient must be given a choice as to whether they wish to participate in educational activities. The principle of seeking consent for education are identical to those applied to the clinical situation. Advanced decision. Advanced decision, sometimes colloquially described as living wills, enable peoples to express their wishes about a future treatment or intervention. The decisions are made in the anticipation at a time when a person ceases to have capacity. Different countries have differing approaches to advanced decision making, and it is necessary to be aware of the relevant law in the area in which one is practicing. Within the UK, advanced decisions are governed by legislation. For example, the Mental Capacity Act 2005 applies in England and Wales. The criteria for a legal valid advance decision are that it is made by someone with capacity, made voluntarily based on appropriate information, specific and applicable to the situation in which it is being considered. In practice, it is often the requirement of a specificity that is most difficult for a patient to fulfill because of the inevitable uncertainty surrounding future illness and potential treatment or intervention. There is one difficulty that for many goes to the heart of an ethical objection to advanced decision making, namely that it is difficult to anticipate the future and how one is likely to feel about that future. Scope. An advanced decision can be made to refuse treatment and to express preferences, but cannot be used to demand treatment. In general, no patient has the right to demand or request treatment that is not clinically indicated. Therefore, it would be inconsistent to allow patients to include in their advance decision request for specific treatment. Treatment procedure and intervention. An advanced decision cannot be used to refuse basic care such as maintaining hygiene. Format. Advance decisions are made orally or in writing. However, advance decision on withdrawal or withholding of life sustaining treatment must be in written form and witnessed, and the decision should state explicitly that it is intended to apply even to life-saving situation. The more informal and non-specific the advance decision is, the more likely it is to be challenged or disregarded as being invalid. If working in a country where advanced decisions are recognized, clinicians should make reasonable attempt to establish whether there is a valid advance decision in place, and the presumption is to save life where there is ambiguity about either the existence or content of an advance decision. Advance decision should be periodically reviewed, and amendment, revocation, or addition are possible provided that the person concerned still has capacity. Ethical and practical rationale. The ethical rationale for the acceptance of advance decision is usually said to respect for patient autonomy and represent the extension of the right to make choice about health care in the future. True respect for autonomy and the freedom to choose necessarily involves allowing people to make choices that others might consider misguided. Some suggest that giving patients the opportunity to express their concern, preferences, and reservation about the future management of their health foster trust and effective relationship with clinicians. However, it could also be argued that none of us will ever have the capacity to make a decision about our future care because the person we became when ill is qualitatively different from the person we are when we are healthy. Lasting power of attorney. Many countries allows the appointment of a proxy or for a third party to make substituted judgment for people lacking capacity. In England and Wales, consent for or refusal can be expressed by someone who has been granted a lasting power of attorney, that is LPA, once a person lack of capacity has been registered with the public guardian and the lasting power of attorney granted. The person holding the power of attorney is charged with representing a patient best interest. Therefore, it is imperative to establish whether there is a valid LPA in respect of an incapacitous patient and to adhere to the wishes of the person acting as attorney. The only circumstances in which clinician need not to follow the LPA is where the attorney appears not to be acting in the patient best interest. In such situation, the case should be referred to the court of protection. Like advance decision, the ethical rationale for the existence of LPA is that prospective autonomy is desirable and facilitates informed care rather than second guessing patient preference. Best interest of a patient who lack capacity. Where an adult lacks capacity to give consent and there is no valid advance decision or power of attorney in place, clinicians are obliged to act in the patient's best interest. This encompasses more than an individual based medical interest. In practice, the determination of a best interest is likely to involve a number of people, for example, member of the healthcare team, professionals with whom the patient had a longer term relationship, and relatives and carers. In England and Wales, the Independent Mental Capacity Advocacy Service provides advocates for patients who lack capacity and have no family or friend to represent their interest. Parties in such a situation include independent mental capacity advocate are not making decision. Rather, they are being asked to give an informed sense of the patient and his or her likely preference. In some jurisdiction, example in North America, clinical ethics play an advocacy role and seek to represent the patient best interest. Provision of a cessation of life sustaining treatment. A common situation requiring determination of a patient's best interest is the provision of a life sustaining treatment, often at the end of life, for a patient who lacks capacity and has neither advance decision nor an attorney. It is considered acceptable not to use medical means to prolong the lives of the patient, where based on good evidence, the team believes that further treatment will not save life. The patient is already imminently and irreversibly close to death. The patient is so permanently or irreversibly brain damaged that he or she will always be incapable of any further self directed activity or intentional social interaction. Moral and religious belief vary widely, and in general, decision not to provide or continue life sustaining treatment should always be made with as much consensus consensus as possible amongst both the clinical team and those close to the patient. Where there is unresolvable conflict between those involved in decision making, a court should be consulted. In emergencies in the UK, judges are always available in the relevant court. Where clinicians decide not to prolong the life of a imminently dying and extremely brain damaged patient, the legal rationale is that they are acting in the patient's best interest and seeking to minimize suffering rather than intending to kill, which would constitute murder. In ethical terms, the significance of intention, along with the moral status of act and omission, is integral to debate about assisted dying and euthanasia. Assisted dying. Currently, in many countries, there is no provision for lawful assisted dying. For example, physician assisted suicide, active euthanasia, and suicide pacts are illegal in the UK. In contrast, some jurisdictions include Netherlands, Switzerland, Belgium, and certain states in the US permit assisted dying. However, even where assisted dying is not lawful, withholding and withdrawing treatment is usually accepted in strictly defined circumstances where the intention of the clinician is to minimize suffering, not to cause death. Similarly, the doctrine of a double effect may apply. It enables clinician to prescribe medication that has as its principal aim the reduction of suffering by providing analgesic relief, but which is acknowledged to have side effects such as the depression of a respiratory effect, example opiates. Such prescribing is justifiable on the basis that the intention is benign and the side effect, whilst foreseen, are not intended to be the primary aim of a treatment. End of life care pathways which provide for such approach where necessary are discussed in chapter number 10. मात्र इतना पढ़ पाया हूँ. रेस्ट नहीं. जय शिव शंकर. Although assisted dying is unlawful in the UK, the Director of Public Prosecution (DPP) has issued guidance on how prosecution decisions are made in response to a request from the courts, following an action brought by Debbie Pudi. Thus, there are now guidelines that indicate what circumstances are likely to weigh either in favor of or against a prosecution. Nevertheless, the law itself is unchanged by the DPP guidance for a clinician to act to end a patient's life remains a criminal offense. Mental health and consent. The vast majority of people being treated for psychiatric illness have capacity to make choice about health care. However, there are some circumstances in which mental illness compromises an individual capacity to make his or her own decision. In such circumstances, many countries have specific legislation that enable people to be treated without consent on the basis that they are at risk to themselves and to others. People who have or are suspected of having a mental disorder may be detained for assessment and treatment in England and Wales under the Mental Health Act 2007, which amended the 1983 statute. There is one definition of a mental disorder for the purpose of the law. The Mental Health Act 2007 defines a mental disorder as any disorder or disability of the mind. Addiction to drug and alcohol is excluded from the definition. Appropriate medical treatment should be available to those who are admitted under the Mental Health Act. In addition to assessment and treatment in hospital, the legislation provide for supervised community treatment order, which consists of a supervised community treatment after a period of detention in hospitals. The laws is tightly defined with multiple checks and limitations which are essential given the ethical implication of detaining and treating someone against his or her will. Even in situations in which it is lawful to give a detained patient psychiatric treatment compulsorily, efforts should be made to obtain consent if possible. For concurrent physical illness, capacity should be assessed in the usual way. If the patient does have capacity, consent should be obtained for the treatment of a physical illness. If a patient lacks capacity because of the severity of a psychiatric illness, treatment for physical illness should be given on the basis of a best interest or with reference to a proxy or advance decision. If treatment can be postponed without seriously compromising the patient interest, consent should be sought when the patient once more has the capacity. Then consent and the children. Where a child does not have the capacity to make decision about his or her own medical care, treatment will usually depend upon obtaining proxy consent. In the UK, consent is sought on behalf of the child from someone with parental responsibility. In the absence of someone with parental responsibility, example in the emergencies where treatment is required urgently, clinician proceed on the basis of a child's best interest. Sometimes parents and a doctor disagree about the care of a child who is too young to make his or her own decision. Here both national and European case law demonstrate that the court are prepared to override parental beliefs if they are perceived to compromise the child's best interest. However, the court have also emphasized that a child's best medical interests are not necessarily the same as a child's best overall interest. Whenever the presenting patient is a child, a clinician are dealing with a family unit, sharing decision and paying attention to the need of a child as a member of a family are the most effective and ethical ways of practicing. As children grow up, the question of whether a child has a capacity to make his or her own decision is based on the principle derived from a case called Gillick v. West Norfolk and Wisbech Area Health Authority, which determined that a child can make a choice about his or her health where the patient, although under 16, can understand medical information sufficiently. The doctor cannot pursue the patient to inform or give permission for the doctor to information his or her parents. In cases where a minor is seeking contraception, the patient is very likely to have sexual intercourse with or without adequate contraception. The patient's mental, physical health, or both are likely to suffer if treatment is not provided. It is the patient's best interest for the doctor to treat without parental consent. The Gillick case recognized that children differ in their ability to make decisions and established that function, not age, is the prime consideration when considering whether a child can give consent. Situations should be approached on a case by case basis, taking into account the individual child level of understanding of a particular treatment. It is possible and perhaps likely that a child may be considered to have capacity to consent to one treatment but not another. Even where a child does not have a capacity to make his or her own decision, clinicians should respect the child's dignity by discussing the proposed treatment, even if the consent of parents also has to be obtained. In the UK, once a child reaches the age of 16, the Mental Capacity Act 2005 states that he or she should be treated as an adult save for the purpose of advanced decision making and appointing a lasting power of attorney. Confidentiality. Confidentiality is essential to therapeutic relationship. If clinicians violate the privacy of their patient, they risk causing harm, disrespect autonomy, undermine trust, and call the medical profession into disrepute. The diminution of trust is a significant ethical challenge with potential serious consequences for both the patient and clinical team. Within the UK, confidentiality is protected by common and statutory law. Some jurisdictions make legal provision for privacy. Doctors who breach the confidentiality for patient may face severe professional and legal sanction. For example, in some jurisdictions, to breach a patient confidentiality is a statutory offense. Respecting confidentiality in practice. Patients should understand that information about them will be shared with other clinicians and healthcare workers involved in their treatment, usually by giving consent for investigation or treatment. Patients are deemed to give their implied consent for information to be shared within the clinical team. Very rarely, patient might object to information being shared even within a team. In such situation, the advice is that patient wish should be respected unless it compromises treatment. In almost all clinical circumstances, therefore, the confidentiality of the patient must be respected. Unfortunately, confidentiality can be easily breached inadvertently. For example, clinical conversation takes place in lifts, corridor, and caves. Even on ward, confidentiality is routinely compromised by the proximity of a bed and the visibility of a whiteboard containing medical information. Student and doctors should be alert to the incidental opportunities for breaches of confidentiality and seek to minimize their role in unwittingly revealing sensitive information. When confidentiality must or may be breached, the duty of confidence is not absolute. Sometimes the law requires that clinician must reveal private information about patient to other. even if they wish it were otherwise. Box 1.5. There are also circumstances in which a doctor has the discretion to share confidential information within defined terms. Such circumstances highlight the ethical tension between the right of individual and the public interest. Aside from legal obligation, there are three broad categories of qualifications that exist in respect of the duty of confidentiality, namely, the patient has given consent, it is the patient's best interest to share the information, but it is impracticable or unreasonable to seek consent. It is the public interest. These three categories are useful as a framework within which to think about the extent of the duty of confidentiality, and they also require considerable ethical discretion in practice, particularly in relation to situations where sharing confidential information might be considered to be in the public interest. In England and Wales, there is a legal guidance on what constitutes sufficient public interest to justify sharing confidential information, which is derived from the case of W.V. Asdell. In that case, the Court of Appeal held that only the most compelling circumstances could justify a doctor acting contrary to the patient's perceived interest in the absence of consent. The court stated that it would be in the public interest to share confidential information where there is a real and serious risk of harm. The risk is a physical harm. There is a risk to an identifiable individual or individuals. Consent should be sought wherever possible, and disclosure on the basis of the public interest should be a last resort. Each case must be weighed on its own individual merits, and a clinician who chooses to disclose confidential information on the ground of public interest must be prepared to justify his or her decision. Even where disclosure is justified, confidential information must be shared only with those who need to know. If there is a perceived public interest risk, does a doctor have a duty to warn? In some jurisdictions, there is a duty to harm, but in England and Wales, there is no professional duty to warn others of a potential risk. The judgment of W.B. Esdale provides a justification for breaches of confidence in the public interest, but it does not impose an obligation on clinicians to warn third parties about potential risk posed by their patient. Resource allocation. Resource should be considered broadly to encompasses all aspects of a clinical care, that is, they include time, knowledge, skill, space, as well as treatment. In circumstances of scarcity, waste, and inefficiency of any resource are of ethical concern. Access to healthcare is considered to be a fundamental right and is captured in international law since it was included in the Universal Declaration of Human Rights. However, resources are scarce, and the question of how to allocate limited resource is a perennial ethical question. Within the UK, the courts have made it clear that they will not force NHS trust to provide treatment which are beyond their means. Nevertheless, the court also demands that decision about the resource must be made on a reasonable grounds. Fairness. both ethically and legally. Prejudice and favoritism is unacceptable. Methods for allocating resources should be fair and just. In practice, this means that scarce resources should be allocated to patients on the basis of their comparative need and the time at which they sought treatment. It is respect by clinician for this principle of equality, equal needs and equal chance that fosters fairness and justice in the delivery of a healthcare. For example, a well-run accident and emergency department will draw on the principle of equality of need and chance to decide who to treat first and how. Offer treatment that has been shown to deliver optimal result for minimal expense. Use triage to determine which patients are most in needs and ensure that they are seen first. The QI waiting list being based on need and time of presentation. People should not be denied potentially beneficial treatment on the basis of their lifestyle. Such decisions are almost always prejudicial. For example, why single out smoker or the obese for blame, as opposed to those who engage in dangerous sports. Patients are not equal in their abilities to lead healthy lives and to make wise healthcare choices. Education, information, economic worth, confidence, and supports are all variables that contribute to the socially determined health and well-being. As such, to regard all people as equal competitors and to reward those who, in many ways, are already better off in unjust and unfair. Global perspectives. Increasingly, resource allocation is being considered from international or global perspectives beyond the boundaries of the NHS and the border of the UK. The moral questions about the availability of and access to effective healthcare are rightly attracting the attention of ethics and clinician. Anyone who is training for working in medicine in the 21st century should consider fundamental moral questions about resource allocation, in particular those being raised by issues such as अच्छा यहाँ पर ये एक बॉक्स है Box 1.5 example of circumstances in which a doctor is required to share confidential information. Notifiable disease which by virtue of a public health legislation must be notified to the relevant consultant in the communicable disease control. Court order. Road traffic accident which leads to request from the police actual or suspected terrorist activity. ग्लोबल पर्सपेक्टिव से ये देखेंगे द रोल एंड वर्क ऑफ फार्मास्यूटिकल कंपनीज, द मोबिलिटी ऑफ ट्रेंड क्लिनिशियन, द प्री ऑक्यूपेशन ऑफ फंडेड एंड कमर्शियल बायोमेडिकल रिसर्च विथ डिजीज दैट आर prevalent in developed countries, notation of rights to health and life, the statue of those seeking asylum, persistent inequalities in health, professional competence and mistakes. Professional competence and mistakes. Doctors have a duty to work to an acceptable professional standard. There are essentially three sources that inform what is meant to be a competent doctor, namely the law, professional guidance from bodies such as the GMC, थर्ड हो गया आपका पॉलिसी. इन प्रैक्टिस देयर इज फ्रीक्वेंट ओवरलैप एंड इंटरेक्शन बिटवीन द कैटेगरीज. एग्जाम्पल ए डॉक्टर मे बी बोथ ए डिफेंडेंट in a negligence action and the subject of fitness to practice procedure. Professional bodies are established by and work within a legal framework, and in order to implement policy, legislation is required and interpretative case laws will often follow standard and the law. In most countries, the law provides the statutory framework within which the medical profession is regulated. For example, in the UK, it is the function of the GMC to maintain the register of a medical practitioner, provide ethical guide and quality assure medical education and training, and conduct fitness to practice procedures. Therefore, it is the GMC that defines standard of a professional practice and has responsibility for investigation when a doctor's standard of a practice is questioned. Clinicians have a responsibility not only to reflect on their own practice but also to be aware of and, if necessary, respond to the practice of colleagues, even in the absence of a formal line management responsibility. In England and Wales, for example, the Public Interest Disclosure Act 1998 provides statutory protection for those who express formal concern about colleagues' performance, provided in the expression of a concern constitute a qualifying disclosure, is expressed using appropriate procedure, and is made in good faith. Clinical negligence. Negligence is a civil claim where damage or loss arisen as a result of an alleged breach of a professional duty, such that the standard of care was not on the balance of probabilities that which could be reasonably expected. On the component of a negligence, duty is the simplest to establish. All doctors have a duty of care to their patient, although the extent of that duty in emergencies and social situations is uncertain and contested in relation to civil law. Whether a doctor has discharged his or her professional duty adequately is determined by expert opinion about the standard that might reasonably be expected and his or her conduct in relation to those standards. If a doctor has acted in a way that is consistent with a reasonable body of his peers, and his action or omission withstand logical analysis, he or she is likely to meet expected standard of care. Lack of experience is not taken into account in legal determination of negligence. The commonest reason for negligence action to fail is causation, which is notoriously difficult to prove in clinical negligence claim. For example, the alleged harm may have occurred against the background of a complex medical condition or course of a treatment, making it difficult to establish the actual cause. Clinical negligence remains relatively rare, and undue fear of litigation can lead to defensive and poor practice. All doctors make error, and these do not necessarily constitute negligence or indicate incompetence. Inherent in the definition of incompetence is time, that is ongoing review of a doctor's practice to see whether there are patterns of error or repeated failure to learn from error. Regulatory bodies and medical defense organization recommended that doctors should be honest and apologetic about their mistake, remembering that to do so is not necessarily an admission of negligence. See page 14. Such honesty and humility, aside from its inherent moral value, has been shown to reduce the prospect of a patient complaint or litigation. Professional bodies. Professional bodies have a diverse but often overlapping role in developing, defining, and revising standard for doctors. The principal publication in which the GMC set out standards and obligation relating to competence and performance are duties of a doctor and good medical practice policy. There have been an exponential number of policy reforms that have shaped the way in which the medical competence and the accountability agendas have evolved. One of the most notable is the increase in the number of organizations concerned broadly with quality and performance. The increased scrutiny of doctor competence has found further policy translation in the development of appraisal scheme and the revalidation process. There have been other policy initiatives that adopt the rhetoric of quality, such as increased use of clinical and administrative target, private finance initiative, and the development of specialist screening facilities and treatment center. The issue of professional accountability in medicine is a hot topic. The law, professional guidance, and policy documentation provide a starting point for clinicians. Complaints and possible litigations are often brought by patients who feel aggrieved for reasons that may be unconnected with the clinical care that they have received. When patients are asked about their decision to complain or to sue doctor, it is common for poor communication, insensitivity, administrative error, and a lack of responsiveness to be cited as motivation. See page 7. There is less to fear than doctors sometimes believes. The court and professional bodies are neither concerned with the best practice nor with unfeasible high standard of care. What is expected is that doctor behave in a way that accord with the practice of a reasonable doctor, and the reasonable doctor is not perfect. As long as the clinician adhere to some basic principle, it is possible to practice defensible rather than defensive medicine. It should be reassuring that complaint and litigation are avoidable simply by developing and maintaining good standard for communication, organization, administration, and good habit begin in medical school. In particular, effective communication is a potent weapon in preventing complaint and ultimately encounter with the legal and regulatory system. Thanks for watching.